Welcome to Probate Problems and Practical Solutions.
Welcome back to Probate Problems and Practical Solutions with Carly Whiteside, owner of Copper Wren Law in Mesa, Arizona. Copper Wren Law focuses on probate litigation, guardianship, conservatorship, and trust administration across the state of Arizona. I'm Leanne Lyon, and today Carly is digging into common probate litigation issues in Arizona and how her team can help. Hello, Carly.
Hi, how are you?
It's good to be back. It's good to see you again. You've mentioned that a leading cause of probate lawsuits is a lack of information. How can an Arizona personal representative, sometimes referred to as a PR, use radical transparency to stop a lawsuit before it even starts?
So in my experience, when we have personal representatives, we tell them to over disclose. So send me the whole bank statement. I will redact out what's not necessary. Send me all the pages, even though it says that little disclaimer at the end that we all see about credit increases and that has nothing to do with anything. Just send it to me. That way people can see at the bottom, it says 7 of 7 or 5 of 5. Because what happens is when we leave out information, then people's imaginations can run wild. And so it's better to just give them something that really has nothing to do with anything to show, it really does have nothing to do with anything, as you can see. And then we can always edit things and make sure that personal information is not disclosed. I have also seen, some beneficiary families are closer than others, and so they appreciate a monthly update. And so our clients might put together a monthly email that they send out after talking to us or showing us. Some families don't want the update. It actually causes them stress to know what's continuing to go on. They're just more interested in, hey, when I need to sign something to get money, let me know. So we really kind of discuss that with our clients, like, hey, what do you think the needs are going to be of your family members? Are they interested? Are they not? And then we just kind of customize our basically process from there with them. They know their families best. And as long as we're kind of start off on a good foot, then I found that everything seems to go along pretty smoothly. And it's always more helpful to give them a lot of documents to look at rather than have them come back and say, well, what was this? What was that? We kind of over prepare here, which is not usual. Most firms will kind of do the bare minimum and say, well, if they want to have the information, they can ask. And I have found that usually leads us to issues later.
Wow, I am suddenly really appreciating radical transparency. And I love how you customize that for families. That's amazing. Changing topics a little, a person can be forgetful but still have testamentary capacity. How do you draw the line for an Arizona judge between someone who is simply aging and someone who truly lacks the mental capacity to sign a legal document?
So that is where our attorneys come in. And there's really no set test in Arizona. There's not a set of guidelines where we can pull a list and basically check off. It is up to the attorney to have the conversation with that person and kind of make a determination of capacity in that moment. Capacity can be from hour to hour, day to day, week to week. So when somebody may have capacity on Tuesday and then on Thursday, they don't. And so it's really important that when somebody meets with an attorney to update a will, update a trust, maybe do some new powers of attorney, that they are having an appointment and then they're having a second appointment for the actual signing appointment that's maybe a few days later, a week later, to ensure that, one, nobody is in the background telling mom or dad or sibling to call and giving them a script, and then they don't know why they're there. That's a way we can kind of catch things, is by delaying a signing. It's always a red flag for our office when people call and they need things same day. Mm-hmm. That's typically something where we look into it a little bit deeper. There are scenarios where that's understandable, i.e. maybe somebody is deteriorating very quickly due to a cancer diagnosis or something. And so before they go on all their pain meds, they want to get their stuff taken care of because they're getting ready to go on hospice. So really, honestly, it's the attorney's judgment and determination. And my firm is more conservative in this area. So if we even get kind of they're on the line, we will typically decline. and just say, I'm really sorry. It's too late. If you want to try to call other firms, you absolutely can. But we are not comfortable taking care of that for you. It's just, unfortunately, the window has closed. So that's how we handle that. It's really at the attorney's discretion.
Wow, that's a tough call to make, but somebody fortunately is willing to do it occasionally. And I'm sure that's so important for those families. Related, what are the common patterns of isolation that you see in Arizona cases where a caregiver has manipulated a vulnerable adult into changing their estate plan?
Typically, what we see is the vulnerable person is here and no family is in state, or they're not close. Close is like an hour. So we're in the Phoenix metro area. So if a family member lives in Tucson, it's a little bit difficult for them to get up and everything else. And as I've discussed on other episodes, when you call someone over the phone, it's really easy for them to mask that everything is fine, everything's great, they're good for the 5 to 10 minutes they're on the phone. And then, when you actually go to the house, it's cluttered, it's disheveled, there's no food, there's no substitute for actually physically checking on someone. And so what I see when people are able to kind of wiggle in is when family is not making the actual physical check-ins. They're talking on the phone, they're texting, but nobody's actually going to the house and looking in this person's eyes and looking around at their environment and having a prolonged conversation. Typically what I've seen is people will be on the phone for 5, 10, 15 minutes, and then they get off the phone. And that's kind of the amount of time somebody can use to convince you everything's fine. But when you're with someone for a half hour, 2 hours, 3 hours, the mask falls and they're not able to kind of keep up the front that everything is okay. Families do the best they can if they're out of state and they have to hire a caregiver to come in and provide that person support. I would tell people you want to be extremely careful with that. You do not want to take a friend of a friend who's a nurse practitioner. You don't want to say, oh, well, my neighbor can do it. Very informal setups are where we kind of see these issues because these are not trained professionals. They're just people that are kind of looking for this opportunity. And unfortunately, we do see that a lot here with our aging population. So if you need to have care provided to a family member through in-home care or caregiver, you definitely want to go through a reputable service that does the background checks. These people need to be licensed. Ask a lot of questions. It is not annoying. It is not overstepping. Think of it as if you would need a babysitter for your 2-year-old. You're going to have a lot of questions for that person. You need to make sure who this person is. And, life's kind of a cycle. We all come into this world one way, and if we stay long enough, we go out kind of the same. And so I think a lot of people maybe feel like, ooh, if I ask, I'm annoying, or I don't want to overstep. And it's like, no, this is your family member, and you need to be very, very careful. The world is just unfortunately full of some people that are looking to take advantage. And so it's when family is not able to come and be close on a regular basis.
And have you found situations where those caregivers have manipulated the person that they're caregiving into changing their estate plan?
We have seen that. We've had several cases, not only in this office, but in a previous firm I was at. I have seen caregivers, I have seen CPAs, I have seen financial advisors come in and make themselves the executor, make themselves the trustee, make themselves the sole beneficiary and write out family. I have seen them not just modify estate plans, but take people to financial institutions and put themselves on as the beneficiary designation, which is really hard to address because those pass outside of probate. And so a lot of the times if somebody passes away and you say, for example, oh, I know there's a life insurance policy, let's just say at Mass Mutual. Family calls, hey, they passed away. We know there's a policy. They will tell them, yep, we got notification of that. That policy had a beneficiary on it and it's been paid out. And when you say, well, to whom? They say, none of your business. And then they hang up on you. So a lot of the times this stuff is absolutely discovered after somebody's passed away. Very rarely is it discovered previously because it's being concealed. And a big contributor to this being successful is document preparers, which are not attorneys. They are licensed by the state of Arizona through a kind of civil division through the Supreme Court, but they do not have bar numbers. They are not supposed to give legal advice, but I have found that they are usually the ones behind these amended documents because, as I mentioned for the first question, attorneys evaluate capacity. Who's the person calling the firm to make the appointment? Who's bringing them? Who's trying to be in the room with them? Who are you? Why is the family member not here? There's just some things that a law office will look at and pick up on. And unfortunately, document preparers being unable to give legal advice, you basically tell them, write this down. And they say, okay. And they don't really make capacity determinations. They don't ask questions because typically that involves legal advice. So it's unfortunately kind of a loophole that I've seen be exploited. And it's super unfortunate because it's very hard to go into court and unwind documents once they've been signed, notarized, and, even locating the documents. Sometimes they're hidden.
Right. Well, in wills, we know that even a single poorly phrased sentence can lead to years of litigation. How does Arizona law handle interpreting ambiguous documents when the person who wrote them is no longer here to explain?
Well, typically, the phrase or paragraph, whatever it may be, can be interpreted one of two ways. And typically there is a person on one side advocating for it to be read one way, and you have a person on the other side advocating for it to be read another way. That's where the litigation comes from. A lot of the times we will try to do a mediation or a settlement conference with a currently presiding probate judge or commissioner to get their opinion of like, hey, if this was in front of you, how would you rule? To kind of get an idea of where this is going if it were to go to trial. Sometimes private mediators can be involved and they will give you their 2 cents, like, well, if I was fighting this on your side or their side, or if I was the judge, here's how I would interpret it. So unfortunately, there's really no fast track or easy way to resolve those ambiguous claims other than just through the process of litigation with the hope that we can come to a settlement. And a lot of the times in those cases, we split it. No side really gets what they want, which is usually when you've reached a good settlement is when nobody's super happy. Everybody's kind of like, eh. That's how we know we've kind of done a good job because we truly did meet in the middle. So yeah, unfortunately, there's just really no fast track or anything you can pull on to resolve it quickly.
Yeah. I know you often help clients balance that emotion versus practicality. How do you advise a client when they want to spend, say, $50,000 in legal fees to fight over a sentimental item worth $500?
Again, that's kind of falls into the attorney's realm of deciding if they want to help them with that. I will tell you, in all the cases I have seen where that situation you just put forward, where there's a sentimental item and there's a large possibility that a lot of money would have to be expended to recover it, get it appraised, whatever the case may be to deal with the item, Elizabeth very much does not encourage spending money for sentimental things. And so there's been times where she has just said, if that's the direction you want to go, you need to find another attorney. I'm not going to put my bar license on the line to even bring this position forward. It's just not something that we do here. There are plenty of attorneys that will fight for personal items and want to spend your money. We just say we won't. We go through a cost benefit analysis with the client during a call. And when I say we, I mean Elizabeth. I'm usually on just to listen. But those are attorney steered conversations, and they fall under the purview of the attorney assigned to the matter, because in these types of cases, the client tells us where they want to end up. They tell us their destination, and then Elizabeth or the attorney will decide the path to take. So it's like, do we go through the forest? Do we go around the canyon? Or do we go under the bridge? How do we get there? And so that's how we explain things to our clients of, you can take door 1 and door 2. Here's the benefits, and here's the the cons, and then we let them pick. But if it gets into a ridiculous situation like you just described, Elizabeth will come in and kind of give them the hard news of like, no, we're not doing that. Sorry. It's totally unreasonable. It's a bad position. You're going to get hit with attorney's fees from the other side. It opens up a Pandora's box that you really don't want to open.
What is your team's strategy when one side in a probate dispute is completely uncooperative or simply just refuses to communicate?
Unfortunately, there's a lot of steps we have to do, as unfair as it is. So we have to try to over communicate with them. And that means leaving a voicemail, sending an email, even sending a hard letter via certified mail. We attempt, we get to a certain place, which it just kind of depends on the matter, what that is. So I can't say it's after 2 months, after 3 months. It depends on kind of what's going on with the matter. But we do get to a certain choke point where enough is enough. And then there's a mechanism in the probate courts and in courts in general where you can basically file saying this person is not participating in their matter. You can't just throw out an allegation and then disappear. You have to actually bring your claim forward. You have to prosecute your case. And so we can ask for a dismissal of their opposing position, saying they're not doing anything. You can't just hold all this up and float off into the ether and make us continue to prove our case. So then it goes in front of a judge. The other side has an opportunity to appear and object and talk about it. And so kind of like what I said before, there's really no fast track on that one. It really depends on the matter. It depends on, how aggressive do our clients want us to be about it? Is there enough money or assets that are in danger of being either sold or damaged, or that would require us to move a little quicker? And so there's a lot of factors that go on how we actually move that through, but it is possible. And we have done it before on one where somebody came in and said, I have a will. And we say, we have a will. And then they just didn't do anything. And so we're like, can we be done with this silliness? And the court was like, yeah. And we've had other ones where they overfile. It's usually non-represented people. They'll file too many things. They'll just keep filing stuff that's handwritten that is nonsensical, is not appropriate. And so sometimes people over participate, and that's just as damaging because we have to respond to everything. Otherwise they could get it granted, as silly as it is. So we have these two extremes that we run into quite often, but they have the same mechanism for resolution.
Well, you often see DIY filings backfire. What is one specific example mistake in Arizona probate filing that almost always leads to expensive multi-year litigation?
When you have a non-represented beneficiary, typically a child, parent has passed, and there's multiple siblings, and they file with the court that they are the only heir, and they also try to execute what's called a small estate affidavit in Arizona, which is something we use to avoid probate if the estate is small enough. Unfortunately, it doesn't go through the courts. Sometimes for personal property, it's just something you can print off and sign. And so again, some people don't discover it until after it's already been cashed out. The good news with those situations is the institution always retains a copy of the affidavit. And so we see exactly who submitted it. It has to be notarized. So they perjured themselves on this document. But now we have a giant thing to clean up and start and try to recover. So those are what I see is when people try to basically sneak around their other siblings and say, no, there's nobody else. It's just me. Because the institutions go, well, you're telling me it's true, so you'll get in trouble, not me. I'm not going to do a family tree search, which is not reasonable for every single thing. So that's where I see the most issues are those kinds of things where they're saying, nope, just me, nobody else.
Wow. Well, that was very informative. And for today, that's it for today's episode of Probate Problems and Practical Solutions with Carly Whiteside of Copper Wren Law. To learn more about Carly and her team and how they support Arizona families through probate, guardianship, and trust administration, visit copperwrenlaw.com. Thanks for listening, and remember to like, leave a review, and subscribe to the show so you don't miss the next episode. Thank you, Carly.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.